He thought the house was his greatest weapon. He was wrong. It was hers. The morning air inside Courtroom 14 tasted like recycled carpet and fluorescent light, the kind of cold that bureaucracies manufacture to remind you that nothing warm happens here. The gallery was packed. Word had traveled fast in the way that word always travels. When someone important is about to humiliate someone, they've decided doesn't matter. Wooden benches creaked under the weight of people who had driven 40 minutes to watch. Attorneys shuffled paper. Clerks murmured into phones. A bailiff stood by the side door with his arms crossed and the expression of a man who had seen every variety of human theater and been impressed by none of it. And at the plaintiff's table, a woman named Claire Maddox sat perfectly still, spine straight, hands folded on the table in front of her, eyes fixed on a point somewhere just beyond the wall. With the particular stillness of someone who has already seen the ending and is simply waiting for everyone else to catch up. She was 41 years old. She was wearing a dark navy blazer she had bought 2 weeks after the divorce papers arrived, specifically because it was the kind of blazer that communicated nothing, that gave nothing away, that was the visual equivalent of a sealed envelope. Her hair was pulled back. She wore no jewelry except a small watch. She had rehearsed nothing about her appearance. Every choice had been made the way she made most choices in those months. Deliberately, without sentimentality, with an eye toward what would matter later, and not what felt good now. Across the aisle, her husband of 11 years, Richard Maddox, leaned back in his chair with the casual confidence of a man who had never once in his adult life been told no, and had come to believe that streak was a product of his own character rather than his circumstances. He wore a charcoal suit that cost more than most people's monthly rent. His shoes were Italian. His watch was the kind that had a name people said with reverence at the sort of dinners Claire had attended for 11 years while Richard networked, and she stood beside him, being described as Richard's wife, by people who knew she had an MBA and chose not to use that information. He smiled at something his attorney said. He straightened his cuffs. He did not look at Claire. He hadn't looked at Claire. Really looked, as if she were a person who might surprise him. In a very long time. That was mistake number one, of many. Diana Maddox, Richard's mother, was seated in the third row of the gallery. 2 seats to her left sat Serena Voss, who had made the calculation that attendance communicated confidence and had dressed accordingly. A structured blazer, hair-pinned, the deliberate composure of someone performing the role of uninvolved professional with moderate conviction. She had neither spoken to nor looked at Claire. She had been engaged since entering in a careful study of her own hands, which suggested that some part of her understood the confidence around her was not entirely warranted. She had come, as she came to most things in her son's life, to witness his victory. She was 71 and wore cream-colored blazers, the way other people wore armor, deliberately as a signal of station rather than warmth. And she had never once in 11 years referred to Claire by her first name without a fraction of a pause before it, the kind of pause that communicates a person's relationship to a word without requiring them to say anything directly objectionable. Diana had told Richard 6 months earlier, when the divorce was first announced within the family, that Claire would settle for something reasonable, because women like Claire, and Diana meant women without family money, without inherited standing, without a name that opened rooms, always settle. They're practical, Diana had said over lunch with the confidence of a woman who had spent her entire life in rooms where people like Claire served the food. She'll take what's offered and move on. Diana had not once considered that Claire might not be settling, that Claire might be waiting, because Claire had been watching, very, very carefully, for a very long time. They had met 17 years ago at a fundraiser for a children's hospital that Richard's family used primarily as a tax vehicle and secondarily as a social calendar event. She was finishing a graduate program in corporate finance at a university Richard could not have gotten into on his own merits. He was freshly installed as VP of his father's real estate development firm, Maddox Capital Group, having earned the title the way men like Richard earn most things, by being born, and then by being present at the right table when the chairs were assigned. He was charming in the way that people who have always been catered to can sometimes be charming, effortlessly, reflexively, because they've never had to try, and the ease of it reads as confidence rather than the absence of obstacles. She was sharp in the way that people who have had to build everything themselves tend to be sharp, precisely and without waste, and with a very accurate sense of what things are actually worth. For the first few years, it was, by all outward appearances, a marriage. They bought the house in Whitmore Hills, a 7,000 square foot property on 2 acres that Richard insisted they call the estate, a habit Claire found privately exhausting in the way that all small pretensions eventually exhaust the person who doesn't share them. The house had 6 bedrooms, a chef's kitchen Richard never cooked in, a library he used to store golf equipment, and a back terrace that Claire genuinely loved, especially in the evenings in late summer when the light came across the hills at an angle that made the whole property look like something worth saving. She consulted informally on 3 of Maddox Capital's subsidiary deals in the first years of the marriage, financial modeling work that would have cost the firm $200,000 if performed by an outside analyst, work that Richard never formally credited her for and never mentioned in meetings, work he occasionally referenced to colleagues as input from our internal team. She redecorated the house. She raised their son, Marcus. She attended firm dinners and charity events and holiday parties, made conversation with Richard's business partners, smiled at Jeffrey Hale's wife across countless dinner tables. She managed the household accounts with the precision of someone trained to find the place where numbers don't behave the way they should. She had also, quietly and without announcement, started keeping records. It began with a single bank statement she wasn't supposed to see. This was not a dramatic moment. It happened on a Tuesday morning in February while she was sitting at the kitchen island with coffee, looking for a household account transfer. And she found instead a transaction on a subsidiary account she didn't recognize. A wire transfer to a company called Linden Asset Holdings, LLC, for $218,000. The entry was unremarkable in its formatting. It was remarkable in every other way. She didn't recognize the receiving entity. She knew every entity in Richard's standard operational portfolio. She had helped structure 2 of them. When she mentioned it casually to Richard over dinner that evening, keeping her voice level, keeping her fork moving, keeping her eyes on her plate as if the question were an afterthought, he told her it was a routine intercompany loan, a receivable transfer between operating subsidiaries, nothing she needed to worry about. His voice was level. His hand did not shake. He pivoted immediately and smoothly to something Marcus had said at school, and the conversation moved, and they ate the rest of dinner without returning to the subject. Claire said nothing more about it. She simply started writing things down. A folder, then a second folder, then a password-protected spreadsheet on a personal laptop that had never once connected to their shared home network, stored in a case in the back of a closet behind winter coats, in a house where Richard had never once gone looking for anything he couldn't find without her help. She wasn't looking for anything specific in those early months. She was trained to follow the shape of financial behavior before the behavior revealed its intent. She understood at a cellular level that money moves in patterns, and patterns have architects, and architects leave traces whether they mean to or not. She wasn't hunting. She was observing. Over the next 4 years, the thing she was observing became very, very clear. Linden Asset Holdings was one of 7 shell entities. She found them one at a time over the course of 18 months, each connected to the others through shared registered agents, interlocking directorates, and a paper trail that Richard had apparently assumed was both complex enough to be undetectable and simple enough to maintain without dedicated attention. A combination that works only when no one paying close attention is also paying attention to you. Transfers move through the entities in sequences designed to blur origination points. Real property equity was extracted and redeposited in ways that, to a casual outside observer, would look like standard intercompany lending. To someone who had studied financial architecture specifically, who had written a graduate thesis on asset concealment in closely held family corporations, who had sat across from Richard Maddox at dinner for 11 years and had access to household mail and ambient conversations and the particular carelessness that arises when a man has decided his wife is not looking. It looked like exactly what it was. By the time Richard came home on a Tuesday evening in April and told her he wanted a divorce, told her, not asked, standing in the kitchen doorway still in his coat, delivering it with the brisk efficiency of a man confirming a calendar change, Claire had been documenting for 4 years. She had records of 31 months of asset transfers. She had entity formation dates, registered agent addresses, wire transfer cross-references, and 3 sets of property filings that directly connected Maddox Capital's purported ownership of the Whitmore Hills house to a loan instrument she had never been shown and had never signed, and had very specific suspicions about. She knew about Serena Voss, who worked in Maddox Capital's acquisitions division, and had co-signed documentation on 3 recent property purchases, and had been receiving transfers from a subsidiary entity called Voss Linden Partners, LLC, an entity formed 14 months earlier for the past year. She had found that too. She looked at Richard in the kitchen doorway. She said, "Okay." He blinked. He had prepared for a different response. "I'll have my attorney contact yours," she said, and turned back to the stove. She called Patricia Webb the following morning. Patricia Webb had been practicing family law for 26 years and had a reputation in the circuit for being, as one opposing counsel had once reportedly told a colleague over drinks, the legal equivalent of a controlled demolition. She was small, quick-moving, precise, and had a habit of letting opposing counsel believe they were winning for longer than was strictly necessary before adjusting the situation. She sat across from Claire in a conference room on the 14th floor of a building downtown and listened for just under 2 hours without interrupting, taking notes in a small leather journal with a fountain pen, her face entirely neutral throughout. When Claire finished, Patricia looked at the folder. She looked at the spreadsheet printouts. She looked at the property filings. She was quiet for a moment, in the way that people are quiet when they are not thinking of what to say next, but rather of what they are going to do with what they've just received. "How long have you been collecting this?" she asked. 4 years, Claire said. Patricia turned a page in the printout. "He filed the loan documentation last month. His firm is claiming the Whitmore Hills property as business collateral predating the marriage." "I know," Claire said. "He's going to argue you have no claim to the property at all." "I know," Claire said again. Patricia looked at her for a long moment. "You have something on the documentation." It wasn't a question. "I have a suspicion," Claire said carefully, "that I would like verified by someone with the right credentials." Patricia Webb looked at the folder one more time. She said, "He thinks he's already won." "Yes," Claire said. "Good," Patricia said, and reached for her pen. The divorce proceedings began formally in March. Jeffrey Hale, Richard's attorney, a senior partner with a corner office and a client list that read like the contributor page of a business magazine, filed motions in the opening weeks characterizing the Whitmore Hills property as a business asset, specifically as real property collateral, securing a loan from Maddox Capital Group to Richard personally, a loan that Hale's filings asserted had been originated and documented 14 months before the marriage. If the loan predated the marriage, the property could be argued outside the marital estate entirely. Claire would receive nothing from it, no equity, no claim. Not a single square foot of the back terrace she had loved in the evenings. Richard attended the preliminary hearings in varying configurations of confidence. He sat beside Hale with the settled calm of a man who has been told by expensive people that the outcome is certain. He reviewed his phone during recesses. He occasionally looked across the aisle at Claire with an expression that was not quite a smirk, but was adjacent to one. the expression of someone who has decided the contest is over and is now simply enduring the formality of its conclusion. Claire attended every hearing. She wore the navy blazer. She took notes. She said very little. Patricia Webb filed minimal counter-motions in the preliminary phase. She raised no significant objections to Hale's initial documentation submissions. She asked for standard discovery timelines and received them. She was, to all visible appearances, doing exactly what a family law attorney does when the other side has a strong position and good documentation, managing the situation methodically and without drama. Richard noticed the absence of dramatic opposition. He mentioned it to Hale. Hale told him it likely meant the other side was playing for a settlement offer, hoping to negotiate something rather than fight a losing battle at trial. Richard found this satisfying. He had been told by Hale and by his mother Diana and by Serena, who had begun accompanying him to events in ways that were technically discreet but practically obvious, that the property question was closed. Maddox Capital's documentation was in order. The loan predated the marriage. Claire had no standing. He believed them. He had been believing expensive, confident people his whole life, and it had worked out, more or less, every time. The October hearing arrived on a gray Wednesday. Judge Rosalind Fitch presided from the bench with the compressed authority of someone who has been doing this long enough to develop a kind of professional radar for the specific quality of silence that precedes a case going somewhere unexpected. She was 62. She had silver hair she wore without apology, reading glasses she removed and replaced throughout proceedings with practiced efficiency, and a manner of directing the courtroom that communicated, without ever stating directly, that she was aware of every strategy being deployed in front of her and was capable of identifying its weaknesses before the attorney delivering it had finished the sentence. Jeffrey Hale presented first. He was polished, organized, and delivered his argument with the unhurried confidence of a man who has presented winning cases before and recognizes the feeling. He walked the court through the loan documentation, the title records, the entity structure. He submitted the original loan agreement, executed, notarized, dated 14 months before Richard and Claire's marriage, as the central exhibit. He characterized Claire's claim on the property as legally unfounded and noted that the marital estate, properly calculated, did include substantial other assets which had already been documented for fair division. He sat down, looking satisfied. Patricia Webb stood. She thanked the court. She said she had a few questions regarding the submitted documentation and one additional submission she believed the court would find relevant. Judge Fitch said she had 20 minutes. Patricia said she anticipated needing 15. She had spent the 3 weeks since the preliminary hearings doing the work that Jeffrey Hale, in his confidence, had apparently not anticipated needed doing, confirming the authenticity of the opposition's central exhibit. It was not a standard move. Most attorneys in a preliminary property dispute do not commission forensic document analysis on the other side's loan instruments. Not because it isn't occasionally warranted, but because it is expensive, time-consuming, and tends to look like desperation if the document turns out to be genuine. Patricia Webb had done it because Claire had told her, in the conference room on the 14th floor, in a voice that was entirely level, that the loan agreement's execution date could not be accurate because the notary whose name appeared on it had not been licensed in this state at the time. She had looked it up. She had the licensing records. She had simply needed someone with the technical tools to establish the physical evidence to match the paper record. Theodore Park had done that in 11 days. She approached the documentation Hale had submitted and began, methodically and without visible urgency, to ask questions about it. She asked Hale to confirm the execution date. He confirmed it. She asked him to confirm the notary's name and seal as it appeared on the document. He confirmed both. She asked him to confirm that Maddox Capital's position was that this document was original, unaltered, and had been in the firm's files since its stated execution date. He confirmed all of it. Patricia said, "Your Honor, I'd like to call a witness." The rear doors of the courtroom opened. Theodore Park walked in at a pace that was neither hurried nor slow. The pace of a man who has testified in enough proceedings to know that the entrance itself is information, and that information is best delivered neutrally. He was 53, wore rimless glasses and a charcoal blazer, and carried a slim briefcase with the same matter-of-fact efficiency with which a surgeon carries instruments, tools of the trade, nothing more, nothing less. He had testified as a forensic document analyst in 47 cases over a career spanning 22 years. His client list included 3 federal agencies, the U.S. Postal Inspection Service and the State Attorney General's Financial Crimes Division. He was sworn in. He was seated. He opened the briefcase. Patricia asked him to describe for the court the findings of his analysis of the loan documentation submitted by Maddox Capital Group. Theodore Park looked at the document. He looked at the court. He spoke in the measured, technical cadence of someone whose entire professional value is the precision of his language. The document had 2 problems. The first was the paper stock. He had conducted spectrographic analysis of the paper's fiber composition and identified a watermark pattern consistent with a production run from a specific commercial paper manufacturer. A run that the manufacturer's own archived production records confirmed had not occurred until 9 years after the document's stated execution date. The paper on which the loan agreement was printed had not existed when the loan agreement claimed to have been signed. He paused. The second issue was the notary seal. The notary whose name and license number appeared on the document as the certifying official had not been licensed to practice as a notary in this state until 7 years after the date on which they had ostensibly witnessed and certified the execution of the agreement. The document was not original. The document was not authentic. Based on the analytical techniques applied, paper dating, ink composition, seal embossment depth, Theodore Park's professional assessment was that the document had been fabricated approximately 18 to 24 months ago. 18 to 24 months ago. Inside the marriage, inside the 31-month window Claire had been documenting. The silence that followed was the pressurized kind, the kind that fills a room the way water fills a sealed container. Evenly, completely, with no remaining space for anything else. Jeffrey Hale's pen, which had been moving through the hearing in the practiced rhythm of a man taking confident notes, stopped. Richard Maddox's face, which had been performing composure with reasonable success for most of the morning, did something in that silence that it could not entirely suppress. A shift, a flicker, a brief failure of the mechanism that keeps the inside from showing on the outside. It lasted less than 2 seconds. It was enough. Patricia was not finished. She submitted the folder, all of it. 4 years of documented transfers, entity formation records, wire transaction cross-references, registered agent filings and property records, assembled into a chronological exhibit that demonstrated, with the unhurried thoroughness of someone who had been trained to follow financial architecture and had spent 4 years doing exactly that, how Richard Maddox had systematically moved marital assets through a network of shell entities into accounts nominally controlled by his mother, Diana Maddox, and by Serena Voss, whose involvement in the financial structure predated her formal hire at Maddox Capital, and whose role, the records made plain, was not limited to acquisitions work. Diana Maddox, seated 3 rows back in the gallery in a cream blazer and the pearls she wore as a kind of armor, stood up. She said something that the court reporter would later describe in the transcript as inaudible exclamation. She was asked to sit down by the bailiff at the side door, the one with the crossed arms and the unmoved expression. She sat. She was still. Jeffrey Hale requested a recess. He was granted 10 minutes. During those 10 minutes, he spoke to Richard in a corridor alcove in the focused, quiet, serious tone of an attorney who has just realized he submitted fabricated evidence to a court under his own name and is currently performing a rapid internal calculation about the next several years of his professional life. Richard's responses were not audible from any documented distance, but the posture of both men when they returned to the courtroom had changed in ways that courtrooms notice. Judge Fitch did not recess. She reviewed the submitted materials. She asked Theodore Park 3 additional clarifying questions. She asked Patricia Webb 2. She asked Jeffrey Hale 1, which was whether Maddox Capital had any alternate documentation establishing the loan's origination date in a tone that communicated she already knew the answer. He did not. What followed took 41 minutes and was rendered in the language of formal judicial ruling, but its substance was not complicated. Judge Fitch set aside the fabricated loan documentation in its entirety, holding that it could not serve as evidence of any legitimate financial instrument, and that any property claim predicated on it was without legal foundation. She ruled that the Whitmore Hills property was marital property, fully, legally, without qualification. She awarded Claire a settlement that included the property at its assessed value, a proportional share of the liquid marital assets, and a court-ordered forensic accounting spanning the full 31-month transfer period documented in Claire's exhibit, with any additional recoverable assets to be assessed and added to the settlement upon completion of the accounting. She referred the fabricated documentation to the district attorney's office for review of potential criminal charges related to fraud and the submission of false instruments to the court. Then, she looked at Richard Maddox directly, in the way that judges look at people when they have decided to say something that will not appear in the formal ruling, but will be remembered by everyone in the room. She said that in 19 years on the bench, she had presided over cases involving fraud in many of its varieties. She said she had seen financial manipulation driven by desperation, and she had seen it driven by calculation, and she had seen it driven by the particular species of arrogance that produces in some people the unshakable conviction that they are simply not subject to the consequences that govern everyone else. She said that manufacturing a fraudulent legal instrument, processing it through corporate infrastructure to give it a false patina of legitimacy, and then submitting it through counsel to a court of law was not a clever strategy. It was a crime. And it was, she paused here, a remarkably transparent one for a man who had apparently believed himself to be operating at a level of financial sophistication beyond detection. She said she hoped the Whitmore Hills property had been worth it. Richard said nothing. There was a long moment in which saying nothing was the only available option, and he used it. Serena Voss, in the 3rd row, had gone very still beside Diana. Diana herself had removed her pearls, not deliberately, but in the unconscious way that people under pressure shed the things they wear as signals, as if the body already knows the signal is no longer functioning. She held them in her fist. The bailiff had not moved. The court reporter's fingers had paused above the keys. For 4 seconds, perhaps 5, the room simply held what had just happened inside it, the way rooms do when something cannot be unsaid. Jeffrey Hale gathered his materials with the specific, careful movements of a man performing the physical actions of an ordinary afternoon in order to avoid the appearance of having just experienced a professional catastrophe. He would be filing notifications to his firm's ethics board by the end of the week. He would later characterize this as proactive disclosure. It was 2:47 in the afternoon when Claire Maddox walked out of Courtroom 14 and through the building's main doors and out into the October air. The light was doing the thing it sometimes does in October, flat and golden and specific, falling across the stone steps and the parked cars and the trees at the edge of the lot with an impartial beauty that has nothing to do with what has just happened indoors. She stopped at the top of the steps. She breathed. The air was cold and real and tasted like nothing institutional. Patricia Webb appeared beside her a moment later and stood without speaking for the space of about 4 seconds, which is a long time to stand in silence on courthouse steps, and then said simply, "Well," which is a complete sentence when delivered by the right person with the right weight behind it. Marcus was waiting by the car at the edge of the parking lot. He was 14. He had his mother's eyes and a quality of stillness he had inherited from her without knowing it. He watched her come down the steps and didn't ask anything, because 14-year-olds who have been raised by observant people learn to read what words are not needed for. He opened the passenger door. She got in. He walked around to the other side. She did not look back at the building. She had learned, sometime in the second year of documenting, somewhere between the fourth shell entity and the seventh wire transfer, that the most disorienting thing about discovering a betrayal of this scale is not the anger. The anger is clean, navigable, a thing with a known shape. The disorienting thing is the reorientation of the past. Every dinner, every conversation, every moment Richard had smiled at her across a room while already having made certain decisions. Every one of those moments retroactively became something else. She had spent a long time sitting with that. She had come to understand eventually that the past is not rewritten by the discovery of what was true inside it. It simply becomes more accurate. The dinners were still real. Marcus's childhood was still real. The terrace in the evenings was still real. What had not been real was Richard's version of what those things meant to him. And that version had always belonged to him and never to her. And its revelation changed her ownership of nothing she had actually built. She had built quite a lot. She had built Marcus. She had built 4 years of documentation that a court had just accepted as the definitive account of what was true. She had built, without anyone's permission or knowledge or assistance, the case that had just dismantled everything Richard had spent 31 months constructing. She had done it at a kitchen island, in the margins of an ordinary life, one entry at a time. That was hers. That would always be hers. No forged document, no shell entity, no attorney in a charcoal suit could reach it. She had spent 4 years in that marriage after the moment she decided something was wrong, doing quietly and without announcement the only thing she knew how to do when the numbers didn't add up: trace them, document them, follow them until the shape they made was undeniable. She had not done it in anger, though she had felt anger. She had not done it in desperation, though there were months that tested her. She had done it with the same methodical patience she had brought to everything she had ever built, because she understood, had always understood, in the way that people understand things that have been demonstrated to them by experience rather than simply taught, that a thing documented is a thing that exists independent of whether anyone believes you. The truth, properly preserved, does not require anyone's permission to be true. It waits. Richard Maddox had handed her time. He had handed her 4 years of time by deciding she was not looking. He had handed her access by deciding she was not paying attention. He had handed her the shape of everything by deciding she was not smart enough to recognize it. He had never, not once, stopped to consider what she might be building while he was busy being certain. Jeffrey Hale had not considered it either. That was the thing about systems built on the assumption of another person's limitations. They require that assumption to remain accurate in order to function. The moment it fails, the entire architecture fails with it. Hale had built a legal strategy on a document his client had assured him was legitimate, and had not asked the question that Patricia Webb had asked within the first week: what happens if it isn't? That question, unasked, had cost him more than his client. Here is what men like Richard Maddox never understand, and never understand until it is far too late to understand it usefully. Underestimating someone is not a passive act. It is a choice. And every time you make it, you are not simply making a mistake about that person. You are giving them a gift. You are giving them the extraordinary advantage of invisibility. You are giving them the gift of your own certainty, your own blindness, your own confidence that you have already assessed the situation and found it unthreatening. Claire Maddox walked out of Courtroom 14 on a Wednesday afternoon in October with the Whitmore Hills property, a settlement that would fund the next decade of her life without asking anyone's permission, and the quiet, settled knowledge that the 4 years she had spent at a kitchen island with a folder and a personal laptop and a very accurate understanding of what things are actually worth had been, in the end, the most important work she had ever done. She had not won in that courtroom. She had won 4 years earlier, in a Tuesday morning in February, when she saw a number that didn't add up, and instead of letting it go, she wrote it down. If this story landed with you, leave it in the comments. Tell me what the most satisfying part was. Share this with someone who needs to hear that patience is its own kind of power. And subscribe, because every single week we bring you the stories where the person they underestimated is the one who walks out into the light.